my everything, yeah. My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana. Yeah. Uya matinyana. Oh, uya matinyana. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William me round, come here. 1, 2, 3. William me round, come here. I can breathe without you, say. I can breathe without you. I can move without you, Lord. I can move without you. Who am I without you?
Okay. Hello, everyone, and welcome to another wonderful edition of the program, The Community and the Law. We had a little break. We went by Easter holidays, and right now we are back in our stride, back with you in the community. We're bringing you all the discussions that you need to have when it comes to the law. We're doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Now, they are so generous to give us everything we need to do and every discussion we need to have when it comes to the law. BWF Solicitors are trusted partners. Thank you very much for doing that. And you out there, I want to ask you this question. Do you know that in spite of all the discussion and all the conversation around that, the care worker, the foreign workers coming in the healthcare sector is kind of stopped, and your country or where you're coming from is red flagged, so you can do that. Now, the scheme is not cancelled, it's not abolished. But the question here is, can foreign nurses and other health professionals legally enter the UK to work? We're going to have the answer. We're going to have the explanation of all the things that are going around in the community, and also to let you know how you can put in your application and be successful at it. It's all on the program, The Community and the Law. So tell the person next to you, to tell the person next to him or her, and to tell everybody that we are live on BWTV, BW Radio, and BWF Solicitors. Facebook page. Hello, hello, lovely people. Thank you very much. And I believe that you are all set and ready for us to get into the whole caboodle of that discussion. We're live on BWTV, we're live on BW Radio, we're live on BWF Solicitors Facebook page and on the YouTube page as well. It's the community and the Lord. Today is the 15th of April 2023. It happens to be the second Saturday of the month of April, and we rollickingly doing very well for God, country, and survival. My name is Oreku Owusu Frimpong, and I have the duty and the pleasure to be hosting this program between now and 6 o'clock. That's 2 hours ahead of us. 4 to 6 o'clock BST, 3 to 5 p.m. GMT. Today we're looking at whether health workers and other health professionals, nurses, all that, can they legally enter the UK to work? We'll be looking at that. Lawyer Charles Asmah, my resource person, will be gracious to do that for us. And I want to say that we are doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, we say thank you. Now, in the week, we had the chance of celebrating the birthday of the senior partner of BWF Solicitors. Uncle Ben celebrated his birthday earlier in the week. I want to say, sir, we salute you. God bless you. Thank you for your inspiration. Thank you for your guidance. Thank you for all the things you've done for the community. And we join everybody together to say happy birthday to you. May all you wish for come through. May all you pray for be answered by our gracious and mighty Father up there in heaven. And also may your family flourish so that we can have many of the likes of you. Uncle Ben, happy birthday. Thank you very much, sir, for your guidance. We pray that the good Lord will continue to bless you. So in the meantime, let's take some messages, and when we come back, we'll delve into our discussion, the community and the law, right after these.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited. Located in Temakomji 25 Extension, off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Alex Champong Ministries presents Emmanuel Praise on Sunday, 28th of May 2023 at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Hosted by Alex Champong. Guest artist, Minister OJ and Diana Hamilton. Doors open at 5. Tickets are £25 single, £40 double, £50 VIP, which includes a VIP seat, parking space, meet and greet with the artist, pictures with the artist, VIP snacks and drinks, and the £15 concession rate for children from 4 to 16. Get yours on alexachampong.com or call +44 744 741 7321. Emmanuel Praise with Alex Champong, Minister OJ, and Diana Hamilton. Come praise the Lord with us.
Okay, we're right back. Thank you very much for your time. And we've gone just about 10 and a half minutes into the program. We're moving and soldiering on Forgot, Country and Survival. Today is a very lovely Saturday afternoon. It's just gone past 4 o'clock BST. It's just gone past 3 p.m. GMT. And we are here courtesy BWF Solicitors, a trusted partners when it comes to the law. Today, as I said, we're going to look at a very interesting topic: foreign nurses and other health professionals. Can they still apply to enter the UK for work? I would say you don't have to panic, because really there's good news for you, and there's some positivity around the kind of information probably you have had in the community. So welcome on board. Now, before we move and sojourn on, let me take some of these announcements out of the way. I mentioned to you earlier on that this week we celebrated the birthday of our principal, the senior partner of BWF Solicitors, Uncle Ben. Happy birthday to you again, sir, and may the Lord continue to bless you as he has always done. So with the birthday out of the way, let's also look at other things that we can concentrate on. There's this property that before the Easter break I was talking about, Soenano and Sons Company Limited Real Estate. They call it the City of Favor. Now, City of Favor is located of the Afariwa Junction, CompuGhana Community 25, Tema in Ghana. What they have offered are very wonderful houses to save internal and external securities available, concrete road network, there's a gym, there's a facility for you to go for your medicals as a pharmacy, there's a water fountain, shops, a general car park, forest bar, event centers, a swimming pool, landscaping, a whole lot of activities you can savor. They've got 2-bedroom detached houses, which got several features. They also have a 3-bedroom economy detached house, as you can see on the screen. Then also they have the 3-bedroom detached house, so nicely designed and well built. And then again, we have the 4-bedroom detached house, which has wonderful features, all rooms en suite, paved parking space, plasterboard ceiling. They've got AC point wiring, full level ceramic wall tiles in wet areas, air conditioning, solar powered, and that saves you a lot of money. So how to purchase? So you browse a selection of buildings on their website, and then you complete an application form. You receive an offer letter from SNS Estate. You make a payment. The properties are located to you, and bam, there you go. So yeah, make sure you get in touch with them and get something real good for yourself. If you're preparing to write your English language for any immigration application, IELTS B1, B2 for skilled worker visa routes, healthcare and care worker routes, and other student visa applications, you need to have training and, of course, tutorials from the masters of the game. KT Ed Consults are available for you. Call them on 07596 620154, 07596 620154, or 07512 644 KT Ed Consults. Prepare with the experts and pass with ease. And then I want to remind you that on the 28th, the last Sunday of the month of May, which happens to be the Sunday before the last bank holiday in May, for those of you here in the UK, Emmanuel Praise Alexa Champon Ministries is presenting that, featuring Diana Hamilton and Minister OJ. Now, this is something a program to solicit for funds to buy an incubator for one of the hospitals back in Ghana. So whilst you go enjoy real gospel music, you're also supporting Alex Champon Ministry to get an incubator for the Asamoah Hospital back in Ghana. So those are the announcements I want to get out of the way. Well, I mentioned the birthday of our senior partner. Happy birthday to him once again. But then let's come to where we can get to learn something. BWF solicitors put out the nugget earlier in the week, and it says an application can be made to the court to have an invalid will rectified due to 1, a clerical error, or 2, a failure to understand the testator's instructions. A clerical error can be made by a solicitor, a clerk, a typist, or the testator when he adds something by mistake or omits something he or she intended to insert. In the past few weeks on this program, we've been talking about the wills that we need to write, and also how to get it done properly and rightly. So we have been bringing you bits and pieces as to how you can get a proper understanding of a will and the rest of it. And this one says an application can be made to the court to have an invalid will rectified due to 1, a clerical error, or 2, a failure to understand the testator's instructions. A clerical error can be made by a solicitor, a clerk, a typist, or a testator when he or she adds something by mistake or miss something he or she intended to insert. Now, this one is from the Section 20 of the Administrative of Justice Act of 1982. It's a case Marley versus Rawlings of 2014, which is a Supreme Court, UK Supreme Court ruling. So with that, let me go to my learned friend, my brother, and my resource person for today, Lawyer Charles Asmah. Good afternoon, boss.
Good afternoon, brother.
Thank you very much for joining us.
Pleasure.
Last week, we both have a holiday, so we so refreshed and back
Yes.
to but how's everything at work?
Yes, by God's grace, we are grateful for the gift of life, and to meet the community is quite refreshing all the time.
Right. So I will go to my straight off and ask them. In the past few weeks, we have been looking at what is a will, how to properly do one, and also what may invalidate a will. Today, you are telling us that when we have a will with an error in it, obviously there's a way to correct it, and there must be some reasons as to why the will may be invalid. First of all, let me ask, when a will is determined as invalid, it doesn't end the story that we could be correcting that. But generally, what invalidates a will?
All right, so we are looking at certain things that ought to be made clear, that it is signed by the testator.
Okay.
It has the testator's name,
Right.
and it clearly identifies what the intentions of the testator are as enshrined in the will. Background to that are certain things, age, sound mind, and certain things. But suffice to say that on the paper, on the will itself, we want to see that it's all laid out and the format itself as well. So if you look at a will, we can see that, well, this is valid because of the way it is set out. Look at the signage, the witness, and all that. So we say that if those criteria or those things are present, then we say, yes, it is a valid will. And the next stage is whether it can be contested or not.
Right. Right. So that's not get us telling us that if we see that something is gone wrong, we can rectify that. And it's giving us situations where we can identify that, okay, this has happened, so we can correct that. Are these the only conditions that the law allows that we get a will rectified?
So we have identified certain things that ought to be present. However, if certain things are obviously wrong in terms of the content of the will, then we can say that, well, this is a mistake. But if that mistake is not corrected or adopted, then it validates the will.
Okay.
And once the will becomes invalidated, then the person has died without a will, intestate.
Okay.
So the aim is to ensure that where there has been clerical error, and the error could be by the solicitor who processed the will for the testator, or the testator, him or herself, certain things done, or the typist, or whoever, as we have set out. As long as it's an administrative error, if it is not adopted or corrected, then it invalidates the will.
Okay.
So imagine that we say that this is your Mr. A's will, but at the end of it, it wasn't signed by Mr. A.
Okay.
Then that is not Mr. A's will.
Right.
Then that can invalidate the will, because that will not be approved intention of Mr. A.
Okay.
But it might be a clerical error that will not be fair to hold on to say that the will is not valid. So such clerical errors, the law says that if it is pointed out, the court has the power to correct them. In other words, interpret and make them valid in a way. So we look at Section 20 of the Administration of Justice Act 1982. Also, there's case law, the case of Marley and Rollins 2014. It's a UK Supreme Court case. So you can see that we are looking at fairness as well. Mind you, the person is dead.
Right.
So if we are going to make the will valid, then we have to resurrect the person so that they
come to
do what they
correct
have
it.
to do.
Right.
But it's not possible. And it might also not be fair on the deceased to say that, well, because this wasn't done, it might not be their fault, so you can't even punish them. Even if it is their fault, maybe for human nature and errors are possible. So can the court do something? The law says yes.
Okay.
The court can look at the error and interpret it in a way that will be fair to the testator in terms of intentions of the testator.
Well, then in this situation, when the court allows the correction to be done, the rectification is done, those insertions were made, typos, whatever, those are allowed. When it's done, then it means that it goes to complement the previous one, or invalidates the previous one and probably makes the corrected one valid at that point.
So let's assume that it's a case of he, she, pronoun
Right.
mixed up. It doesn't take away the substance of the will.
Okay.
I suppose it is the form. So once the court allows for the correction of that grammar or what have you, that makes it complete.
Okay.
It doesn't. So we can say that without that, the will is not complete. Therefore, it is not valid.
Not valid, yeah.
But if we say that is the case, then the person would have died intestate and not be fair on the deceased and also other family members whose names have been mentioned in the will. So the aim of the court is to ensure that there is fairness and justice in terms of administration of such estates. And the key thing is the will. So it could be the name that was wrongly spelled. It could be a signature that is mixed up. It could be a certain typo, and so on and so forth. But it is within the court's power to accept that and to have it corrected.
Okay.
And especially if it is coming from a third party, the error is coming from a third party, then oftentimes the court will allow for it to be corrected under Section 9 of Administrative Justice Act.
Okay. So then I want to reiterate and say that an application can be made to the court to have an invalid will rectified due to one, a clerical error, or a failure to understand the testator's instructions. A clerical error can be made by a solicitor, a clerk, a typist, or a testator when he or she adds something by mistake or made something he or she intended to insert. And as we have reiterated severally, Section 20 of the Administration of Justice Act 1982, Marley versus Rollins 2014 case. But lawyer, finally, before we go away from this one, let me ask that lawyers, you pay attention to detail. So if a lawyer comes in to say, well, I made a clerical error, it would be hard to take, wouldn't it?
Well, it also tells you that to err is human. It's only human beings that make mistakes. And therefore, if a human being does not make a mistake, then the person is next to God. So, as human, we are bound to make mistakes depending on the circumstance. And therefore, the court understands that such mistakes are bound to happen. You may say lawyers should not make a mistake, but if such mistakes are not possible, this law would not have been promulgated to make room for such amendment.
Okay. Well, as it were, I kind of put my brother on the spot because obviously when you go to BWF solicitors, there's a lot of attention to detail. So one would sit somewhere and ask, well, lawyers, you are particular, so why would you make a mistake? But to you as human, and to forgive is divine. That's why we're rectification of so many things. Well, it's all about having the law on your side and doing it right. The community and the law is born, and I want to acknowledge that we have so many of our compatriots and lovely people on board. We've taken the nugget out of the way. We're coming to our discussion pretty soon. Jana Miftao says thank you. I think when you got to the link, you said thank you. Jana, please share the link with other people as well. Watching from Hammersmith, Koyotu 4, thank you very much. I think it's also very sunny there as well. Ejiwa Nanajima, good afternoon to everyone. We have Ejiwa also saying, you're late. No, you're not too late. We've just gone through the nuggets, so that's fine. Good afternoon, everyone. Sir Biu is here. We have Sandra Fraser. Good afternoon. I thought it was Sandra Fraser. I saw Fraser. Okay. Terry S. Fraser. Could it be the same person? Well, whatever it is, there's a Madame Fraser somewhere.
Oh, I think yes, the same
Is it same?
person.
Okay.
It's our Sandra.
Oh, so then there's a new name, Cherries. Okay, well, thank you. I love that. Welcome everyone from Chiwo. We have Coco. Good afternoon, Kwiku and the team. That's a strange name, Coco. What's that? Okay. Well, Lyrical Black, good afternoon, Uncle Kwiku and Lawyer. Lyrical Black, thank you for joining us. Odesha Badana Kwiku, may it good evening to everyone. Yes, we have Jana Miftal. Please increase the volume. I think it's quite high. Check your system and let's see what there is. I think that's what you said. Thanks. Okay. Well, we've got that. Kojo24 says, watching from Hammersmith, we've gone through that. Now, if you come in, let's see you, let's hear you. Give us a shout, give us a notification, and let's put ourselves together in a family whilst we learn together. So share the link, tell somebody that we're airborne, and we're going to have a very interesting and important discussion. But first of all, let me say thank you to BWF Solicitors. I'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Well, thank you very much for sticking around. We're back and we're going straight into the discussion. And I know it's been in the community, a lot of people have really talked about that. Now, when you go to the UK government website and there is a section that says Code of Practice for International Recruitment of Health and Social Care Personnel in England, updated on the 23rd of March 2023. Now, it goes on to say that WHO Health Worker Support and Safeguard List has been released, and the UK government has adopted that, and some countries are put in some color-coded categories, and we're going to look at those ones. But first of all, the health professionals and healthcare routes, that bit that where people can come out of the UK or come from outside of the UK to come and work in the healthcare sector. Um, what is it? Does it still persist? Can people really get into that? So let me ask, lawyer, if we talk about the healthcare route, what are we talking about? What category of people can come into the UK to work?
Thank you very much. So, viewers and listeners, today, a very critical topic because it's a global news item now. People are calling here and there asking, well, the UK government is saying no healthcare professional or social worker should enter the UK to work, and it's illegal. Well, it's good news for countries like Ghana and other countries. But there are certain things that we have to understand. Now, we are talking about brain drain
Okay.
and development of nations.
Right.
So a country will spend its resources to train its professionals, and they are taken away by another country. I want us to note the key terms or words. They are taken away by another country.
Right.
So the aim is to ensure that such professionals are not taken away by another country.
Right.
So the question, how do they get taken away by another country? And that is the key focus. Anything outside of that does not cover what the government UK is talking about. And therefore, people are free to do anything outside of this.
Right.
So WHO, the World Health Organization, has its guidelines and code of ethics for international recruitment.
Right.
And international recruitment is defined as agencies, collaborators, local government, and anybody or any group of persons who recruit from abroad foreign workers or who recruit foreign workers to engage in healthcare activities, to engage in health and social care activities.
Okay.
So we're talking about nurses, we're talking about paramedics, we're talking about social workers, we're talking about doctors, and all those range of professionals.
Okay.
Now, how do they do this? They do it by advertising.
Okay.
They do it by marketing. They do it by setting up agencies or other local organizations to canvass people with a view to signing them up for such jobs.
Okay.
So you can see that they follow through all recruitment and selection processes.
Right.
If you do that, the guidelines or the guide by WHO says that you are engaged in active recruitment. So the key word is active recruitment.
Okay.
Now, let's share something from guidelines. It says that active international recruitment in our code of practice is defined as the process by which UK health and social care employers, and this include local authorities, contracting bodies, recruitment organizations, agencies, collaborators, subcontractors, target individuals
Okay.
to market UK employment opportunities to them,
Okay.
with a view to attracting them to migrate to the UK to work in such sectors.
Right.
That is first point. It includes both physical or virtual targeting. So social media targeting or going there in person to talk to people and to say we are recruiting, come and sign up, bring your CV. So physical or virtual. And whether or not these activities lead to signing a person up. So whether you're able to get a person to come to work for you or you don't, you have engaged in active recruitment. And if you do that, the law catches up with you. That is first part. And they said that the code says that if you advertise to candidates through your medium of marketing, incentivizing activities such as referral bonus schemes, referring candidates to specific vacancies in the UK in return for fee from employing organizations. And there is actually a law, Section 6, subsection 1 of the Employment Agencies Act 1973 says that if you are engaging in such activities, you cannot charge.
Okay.
So if the person is charging in active recruitment, it is illegal in the first place anyway. So that is one part. Therefore, with this guideline, anybody who is actively recruiting, the law says you cannot do that. You have to stop. Provided the country you are recruiting from is on the red list of countries.
Now, if you say on the red list, so it means that people can actively recruit from countries that are on the red list.
That are not
on the red list. But if you're on the red list,
then
you can actively recruit
from there. So if the country is on the red list, those are the bad countries. So you cannot recruit from such countries.
Okay.
So if you are going to recruit from a red list country, that is illegal according to the guideline.
Okay. So let me look at, I've got two scenarios here. Let me bring this down and pick this one up. Direct application. So for instance, if I find myself in the red category, for instance, but then for purposes of this code of practice, direct application is when an individual makes an application directly and on their own behalf to an employing organization. Direct applications do not use a third party, such as recruitment organization, agency, or collaboration. So in that case, if I am in the red country and I have had the chance to apply directly to any organization virtually, or probably I even came to the UK on a visit and I saw an advert and I applied to it, and they accept me because I qualify for it. Can I then say that because the country is on the red list, I can't do it?
So that is the exception we'll be coming to.
Okay.
So let's do the background discussion, which addresses the concern we have now.
Okay.
So once we understand the concern, our next question is, and so what?
Right.
Can we still go ahead? Because our topic says we can still go ahead. They will be looking at direct application, resident, and so on and so forth.
So why have countries been put on the red list?
So I started by looking at, talking about brain drain and the need for World Health Organization to prevent other countries from poaching or from taking away professionals trained with the resources of other countries. So if the country is on the red list, what it means is that such country needs its own healthcare professionals
to stay
within their country. And therefore, what they have is not enough. So they are at a critical position where they cannot afford to lose a lot more. So there is more or less a backing from the WHO to ensure that other countries do not poach or go to.
So then sorry, I really interrupted. So it means that if a country is on the red list, they haven't necessarily done anything wrong, but it's a demand or a need thing that one, you don't have to create brain drain, and that the health system in that country on the red list needs resources, so to speak.
Exactly. Okay. So red list doesn't mean they have committed any offense. What they are saying, so it's a protective mechanism.
Okay.
Just like when we had COVID, we had red, amber, green. So that if it's green, you don't have to worry about doing PCR before going to that country. If it is red, then it's a critical because the virus is prevalent. So you have to make sure that those coming are screened properly. So if the country is on the red list, what it means is that its healthcare professionals are getting depleted.
Okay.
So we have to keep an eye.
On the,
And to keep an eye is to restrict countries with the power to recruit from such countries.
okay.
So that actively or normally you cannot go and recruit from there. So we are looking at somebody going there to recruit.
Okay.
Then later we'll come to what if I decide to go and work for somebody else in another country.
Yeah, because you can restrict me on that.
Yeah, so then that will be the second part that we'll be looking at, and that is the key difference.
Okay. So what should people know in the categorization? How would I know that my country is part of that?
Right. So before that, let's go through some of the professions that we are looking at. I mentioned earlier on a couple of them, but we're looking at allied health professionals. So allied health professionals, as we said, paramedics and so on and so forth. We are looking at care workers. We are looking at dentists.
Okay.
We are looking at doctors, healthcare scientists. We are looking at medical staff.
Okay.
Medical staff is also a
Yeah,
healthcare staff, isn't it? But
is it medical staff? Is it those
so it could
involved
be
in the
radiology,
administration?
could be all those aspects. Yes. So if you go to hospital, apart from doctors and nurses, there are a range of other staff, not administrators, because they fall under business delivery. But we're looking at those within the healthcare parameter. So we have we have, apart from that, main consultant, radiologist, we have this, we have that, we have that. So those ones are also medical staff. We are looking at nursing staff, of course, those are nurses. We are looking at residential and domiciliary care workers, so care workers, those who go home to care for people. We are looking at social workers, which mentioned, and support staff and so on and so on. So you can, so the country is saying that health and social care practitioners. Now, the countries that the government is looking at, or those on the red list, suffice for us to go through some of them.
Okay.
Let me go to that list properly. So we have Mozambique, we have Ghana, we have Nigeria, we have, if we're able to get it onto the screen, that will help well. But we have such list of countries.
Right. So if you go to the government website, we'll be projecting that very soon.
Exactly.
Go to the government website and you go to the section that I mentioned earlier on, the code of practice for the international recruitment of health and social personnel in England. You will see that it's there, and it's on one of the annexes where you will find the Annex A lists the countries. So I will be picking up that shortly to give you. Let me do that right away so I can project that. We have.
Right. So whilst we are waiting for
Yeah,
the list to be
Just
projected,
please go
so
on. I'll put the list on.
yes. So
shortly.
what we are saying that if that country is on this list, active recruitment cannot take place in that country. What it means is that if you're a recruitment agency in the UK, you cannot recruit anybody from that country.
Okay.
If you're an organization, an employer in the UK, you cannot recruit from that country.
Right.
And recruitment entails advertising and anything you do to get the person to join you, work for you. So it's a very long list.
Yeah, so we can scroll it down here. You were reading the red countries. we've got it on the screen.
Yes.
Let's see.
So we have
It says Afghanistan, Angola, Bangladesh, Benin, Burkina Faso, Burundi, Cameroon, Central African Republic, Chad, the Comoros, Congo, the Democratic Republic of Congo, La Côte d'Ivoire, Djibouti, Equatorial Guinea, Eritrea, Ethiopia, Gabon, the Gambia, Ghana, Guinea-Bissau, Guinea, Haiti, Kiribati, Lao People's Democratic Republic. That's a new country. Haven't heard of that before. We have Lesotho, Liberia, Madagascar, Malawi, and the list goes
and the
on.
list goes on. And we see Ghana there. So you can see that if somebody is a resident in any of these countries and want to work in the UK, in the healthcare sector, and they want to apply themselves, is different from if the employer is coming to get them to work for them.
Okay.
So we have discussed the point where the employer cannot go and recruit.
All right.
What if I decide to find, as you were asking, direct application? Is it allowed? The law says that this group of bodies or organization cannot go and recruit from there. It doesn't say that if an individual and you want to work abroad, you can't apply.
Right.
And there's no law ever that has been made or can be ever made to say that people cannot work in other countries.
Okay.
Either you be seconded to work there by your own organization, or you find and move to work there.
Right.
So that process will continue. So if you find a job online and you apply,
Right.
you go through the recruitment process and you go through successfully, then they will give you work permit to come and work.
Okay.
That is allowed.
All right. I would want us to look at some scenarios. For instance, there's a nurse resident in Ghana, for instance, and is successful in obtaining a nursing job in the UK hospital, as you're saying. On receiving a formal contract, she questions the repayment clause included for the 14,000. I think there's some situations where there's some compensations and how much you're supposed to be paid. When I come in and it looks like the person is doing me a favor, can I just insist on some of these nitty-gritties and say that the law says X, Y, Z? Then the person will also say, well, you're from a red country, so I am doing you a favor. When such a scenario happens, what should the employer do? What should the employee do?
Yeah, I think it's more to do with what should the employee do than what the employer would have to do. Because the employer knows what to do, but they are refusing to do it.
Okay.
What the employee will do or ought to do is to challenge the employer on the content of the contract.
Okay.
That I applied and I was hired based on this. And especially the remuneration is X. So he cannot downgrade me.
Okay.
That's one. Because the moment you are downgraded, it means you are moved to more or less a different category of work or whatever.
Okay.
So you can challenge the employer. An employer cannot say that after I'm doing a favor. No, you are not doing me a favor. Because if you are doing me a favor, then you have breached the law. In the first place, anyway, because you cannot come and recruit me. I offered, applied, and I have been accepted to work.
For a certain standard.
Exactly.
I've qualified for that. So
yeah, so it's not a favor per se. I don't. Yeah. So of course the employer can say I'm doing you a favor, but you can point out to the employer that no, it's not a favor.
Okay.
This is an agreement or contract. You advertised, I applied, I went through the interview, you hired me on these provisions, and the provisions must be carried.
There's another scenario, very interesting. I am a resident of a red-coded country. For instance, I come from Gabon, for instance. but I'm currently in Canada, which is not on the red list, but I am a citizen or a national of Gabon that's on the red list. Whilst in Canada, when I apply to come and work in the UK in the healthcare or in the health sector, would I be categorized as somebody from the red country or not? Because I live in Canada, but I am a national of Gabon. What
Okay.
happens to me?
Okay, I want to say that it is not your application that matters, because your application is allowed anyway, because that is direct application. So you can apply from whatever country. There is no red list, so there's no listed category for individuals who are applying. But let's go back to your scenario and say that whilst resident in Canada, a UK recruitment agency comes to Canada to say that if you want to work in the UK, come.
Well, that was another angle of it that I would have looked at. But the individual would not have broken the law.
Because individuals are allowed
Okay.
to make open applications
Right. But if there's an advertising campaign in Canada, for instance, and I'm a national
by a UK
yes,
recruitment agency or
yes,
employer.
but I'm a national of a country that's on the red list. But then I find myself in a country that is not that, and a UK recruitment agency does that. When I apply for that, would the UK agency have broken the law?
So that is that point that we're going to look at. Now, you live in Canada on what basis? Either you are domiciled in Canada because you are permanent resident, you have permanent residency in Canada or citizenship in Canada.
Okay.
But you originally, so Canada has become your country of choice, maybe, but your country of origin is Gabon, as you said.
Yeah.
But you are a Canadian resident, or you have citizenship in Canada.
Right.
It might be that you don't have citizenship in Canada or you don't have permanent residence in Canada. However, you are habitually resident. Habitual resident is somebody who lives in that country normally. So if you live there 6 months and over and you've taken that place to be your home, then so to speak, that is your country of residence.
Right.
So are you applying? In that case, if they are recruiting you, will you be recruited from Canada or recruited from Gabon? You'll be recruited from Canada.
Okay.
So this will not apply to you because Canada is not on the red list. And we are not looking, what about if somebody has dual citizenship?
Okay.
Will you then say that because you come from another country and you come from this one is green, the other one is red, so no, it will be too harsh. So we are looking, but so to speak, it's usually the case that such people who will be recruited actively by the employers or the recruitment agencies will be resident in such countries, any of the countries on the red list.
Right.
So they are targeted, and it's not that you point out the individuals to go and recruit, but it's a case of open campaign, and people will buy into that open campaign with a view to coming to directly work for that individual organization that is recruiting. So that scenario you put across, I don't think it will affect, yes. Unless the person was just there in Canada holiday, visit. But if they are going to apply for visa,
They will have to apply.
they have to apply from their country, so they will go back.
Okay. All right. There's a social care provider. He puts out an advert for a number of staff to fill various vacancies. The advert in itself is not targeted at any particular country, but it's open there, probably digitally, online, and all that. Now, this provider receives about 60 applications, and some are coming from green rated countries, some are coming from red rated countries. In this scenario, the nurses that are resident in the red rated countries and made a direct application for the advertised post, how would we categorize them? Would they have applied directly and say that they have not breached any law and their country cannot put any impediments in their way?
So, as you said, they made direct application, but we are looking at the context. So, individuals who apply to foreign employers with a view to be working for such countries abroad would always browse the internet to see job opportunities. And such job opportunity will not be put out for those people or for people in those countries. Ideally, it will be put out for the local people. So I see it advertised on the company's website.
Right.
I show interest. I apply. It might be that the company is not able to find anybody locally and therefore shows interest in my application
Okay.
and arranges to talk to me. Who is approaching the other?
The person looking for the job.
Exactly.
Yeah.
But if it is the vice versa, where the person goes to that country or send people to that country to solicit or to seek interest of people who would want to work, then we can say that is more direct and it's active because it involves processes.
Okay. So who flouts the law? Is it the agency that's advertising, the organization that has the vacancies, or the individual applying for the vacancy?
In terms of the red list provision,
Yes.
it says that if any of the following bodies engages in active recruitment, they flout the law. So it is not the individual that is being recruited actively, but it is the recruiter.
Okay.
So the recruiter could be the agency, could be the local authority, could be the employer, could be collaborators. Collaborators are intermediaries
Okay.
who, so we can say that, oh, we have our collaborators located elsewhere, and therefore we are recruiting through them. Then they're also part of it. So if the employer has collaborators, and the collaborators are the ones recruiting, but with the backing of the employer, then it becomes severally and joint breach.
I have an organization. My HR unit is sublet to an HR specialist. And I ask that all applications are routed through my HR agency. Where does that fall?
So the HR agency is the one recruiting for
They have
you.
applied directly to me, but I refer to that for them to do the vetting and everything.
Well, then that is part of your recruitment process.
Okay.
So I don't think the HR agency is going to get those people. The people have made applications, but as part of your systems, recruitment systems, you have independent body that checks to screen and to make sure that the right candidates are selected. That is a fair recruitment process.
Okay. And can the country from any of the red list, the authorities, the health authorities, or probably the central government, can they stop anybody that has individually applied and has been successful at the job?
How can you do that?
But the WHO is saying that the countries need a number of health workers per a number of a size of.
They can do that positively, but not negatively.
How do they do that positively?
So you put in place how many, of course, in the UK, people travel abroad to work for other countries, but it's negligible. Because to them, there's no incentive to go and work abroad.
Okay.
So the system is such that you are confident that the system will look after you.
Okay.
And therefore, there's no incentive going away.
Yeah.
But such countries on the red list may not have the incentive such that people would want to stay. It might be the job is not available, or even if it is available, the incentivization is not enough. So you compare working home or working abroad, you may choose to work abroad because there's more incentive to work abroad than to stay home and work. And that is the key reason why they are preventing individuals to go and get to recruit, agencies to go and recruit. Otherwise, they can recruit everybody because they have the incentive to get you.
Okay.
So countries can do that. The red list countries can do that by ensuring that they become proactive. How do we retain our the people we've trained with our hard-earned currencies or resources so that they don't leave?
Okay. We live on BW TV, we live on BW Radio, and we're listening to this very interesting discussion, clearing the minds of people when in the past few days we have had in the community that the healthcare route to get people to come work in the UK has been kind of squashed because the countries that were listed are put in the red category. Foreigners and other healthcare professionals, can they come to the UK to work still? Lawyer has said categorically yes, but there are scenarios. There are things you need to do. You don't have to come through an organized campaign to recruit, but if you can do that directly, why not? It's live on BWTV, BW Radio, BWF Solicitors, Facebook, and YouTube. We'll be right back. We're going to say thank you to BWF Solicitors, take a few other messages, and then we'll start taking your questions, your contributions, put them on the platform or in the chat, like the page, share with others, and then again, you can call us on our telephone line 0739920848 or WhatsApp 0795042278. Be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Alex Champong Ministries presents Emmanuel Praise on Sunday, 28th of May 2023 at the Pavilion, 143 to 145 Oxford Road, Reading, RG1 7UY. Hosted by Alex Champong. Guest artist, Minister OJ and Diana Hamilton. Doors open at 5. Tickets are £25 single, £40 double, £50 VIP, which includes a VIP seat, parking space, meet and greet with the artist, pictures with the artist, VIP snacks and drinks, and the £15 concession rate for children from 4 to 16. Get yours on alexichampong.com or call +44 744 741 7321. Emmanuel Praise with Alex Champong, Minister OJ, and Diana Hamilton. Come praise the Lord with us.
Okay, thank you very much for having the patience to wait for us. And we're looking at the topic whether foreign nurses and other healthcare professionals can come to the or enter the UK to come and work. Lawyer mentioned earlier on, Lawyer Charles Asmah, who is resource person, has been dealing with that, and he has mentioned that now there is a categorization: red, amber, and green. Red, amber, and green. Now, in the red category, there's no active recruitment permitted. Red countries are listed in Annex A, as we mentioned earlier on. Amber is managed recruitment permitted and undertaken strictly in compliance with terms of the relevant government-to-government agreement. Active recruitment outside of the government-to-government agreement is not permitted. Then the green, it says active recruitment is permitted. UK has several government-to-government agreements with green-graded countries to set parameters for how UK employers, recruitment agencies, organizations can recruit. Organizations are encouraged to recruit on terms of the government-to-government agreement. Green-graded countries that have government-to-government agreement are listed separately in a B. When you go to the website, you will see that. But let's look at the red countries that we have been looking at. Now, there's a question here that I would want to lawyer bring to your attention. Somebody is asking, what is active recruitment?
All right. Without going by WHO and British government definition, we simply say that active recruitment is where a UK or foreign employer, through advertisement or marketing or recruitment processes, recruits people from abroad to work for them.
Okay.
Or a recruitment agency abroad put in place programs to recruit from abroad with a view to work for designated employers. And this can be done with intermediaries or collaborators or facilitators. As long as it is not the individual worker making the application themselves, but the employer or the agency getting them to make the application, it is active recruitment. And with this, it involves incentivization. They give them bonus schemes. The agency will get bonus schemes for the number of people they recruit, and so on and so forth. So it becomes active. Active simply means that they go through processes to get them, but the aim is to ensure that the individual is recruited by them rather than they themselves making the application.
Okay. Those of you who are with us, if you want to give us a call, you can call on 07399208468 or call us on WhatsApp as well, 07950422780. This one says, Mami Fua says, hi family, hope we're all doing well. Nice to see you again. Nice to see you, Mami Efwa. Another question from Covenant Grace that I will want to let us look at. Assuming I'm a midwife in Ghana and meet all requirements to apply for a job, and I apply directly to MMA Healthcare Recruitment UK, and I get a certificate of sponsorship, can I still go ahead and apply for a healthcare visa?
The answer is yes. And the reason is this. You can see that it's all about I. I find a job, I apply for it, I get selected, and I get an offer.
But there's this caveat says apply to Healthcare Recruitment UK,
So it's I making the application,
not them approaching me.
not they recruiting me.
Okay. All right.
So as long as it's
I see the difference.
yeah,
Okay.
it's I making the application, they have a choice not to select you. So if you meet their criteria of selection, then you may be considered. So if you are considered, then it doesn't mean that it's active recruitment because they did not come to target you per se. You found them,
Okay.
applied to them, and they considered your skill set and thought that, okay, let's consider this person. That's direct application.
Okay. But not active recruitment.
So because it is not the agency coming to recruit you. And mind you, the agency is not going to be paid for that.
Okay. Because you applied.
You applied.
Okay. Now let's look at this one. Well, somebody says, why not? You can do so. Visa application is a different body altogether. If you have your offer to work in the UK, you are good to go. Elizabeth Obeng Poma.
So this response to the one we
that,
answered,
yeah.
yes.
I find very interesting and intelligent people in the class as well.
Yes.
Okay. Now, Covenant Grace, I think, is quite active, bringing a lot of questions here. It says, please, red list countries and the rest list got something to do with coronavirus?
Good point. It has nothing to do with corona. I think we pointed out. It has nothing to do with infection or crime or anything. It is more to do with the danger associated with people leaving that country.
Right.
So if the country is flagged, then it is put on the red list.
Okay.
If it is cool, it's put on the amber list. If it is
Green is open to.
then that's free range. So you see that UK most of the time will go to the Philippines and other countries to recruit. You know, we have a lot of Filipino nurses in the UK because there's this bilateral arrangement with the government there because they are on the green list.
Okay.
So with
Yeah,
that one,
as I read from
Exactly.
the government to government arrangement
exactly.
should be in place.
But if there's no government to government arrangement in place and the country is suffering from active recruitment or suffering from healthcare professionals leaving the country to go elsewhere because they are being recruited, then the country will be flagged up. And it is once it's flagged up, you cannot recruit from there.
Okay.
So you cannot recruit from there, but the individual themselves can find job anywhere.
Oh,
That's the difference.
that's the difference. Thank you very much for the explanation. Emmanuel Johnson says so. Covenant Grace. Why the That's what it is. That's what the law says. Anyway, good afternoon. Does it mean the Home Office has stopped issuing certificate of sponsorship to agencies from the red countries, which include Ghana?
So the agencies are employers. And what they are employers that can allow foreign countries, foreign nationals to work for them.
Okay.
Mind you, if we're an employer in the UK, you employ people from the UK. But if you are employing people from the UK, if the person doesn't have the right to work, you have to give them sponsorship to be able to work for you, just like school.
Right.
Now, if the person is coming from abroad, the person has found the job through from you, and you want to hire them, you should have the power to hire them so that they can apply for visa to come and work for you. Home Office hasn't stopped giving such licenses.
Okay.
So if you have a license from the Home Office, and all you do is not to wait for people to come to you, but you go to them, then you are in trouble.
So you are doing direct,
Then active recruitment.
Okay. Another one here, I wanted to put it. Okay. It says, last year you taught us about a new system of divorce, that is no fault divorce. I think we can still take that. No fault divorce. Does it mean that now that the new divorce law is in force, all divorce applications should be under the new law, that is no fault divorce? Can an applicant or petitioner solely apply for divorce using adultery or unreasonable behavior correctly? Has the no fault divorce law replaced the old system of divorce completely? I think it's about the same thing we said. My friend, that's just called. Just hold on. Let's pick up this answer and we'll come back to you, lawyer.
So the government has simplified the divorce proceedings
Okay.
such that in the past you have to set the grounds. Apart from the fact that the marriage is broken down irretrievably, we have to look at the ground for which you are seeking divorce, be it adultery, separation 1, separation 2, this or that. Now, this time you do not have to say that the person is at fault. That is why I am going to divorce. So as long as the marriage is broken down irretrievably, either party can seek divorce by making an application. Can be sole applicant or joint applicant. Sole applicant means that husband or wife go ahead, make application, then the other party will respond to say, yeah, I agree, let's go ahead. If the person said they don't agree, then the process will move to the next stage. That's the contested proceedings. Now, the process is simplified under the new law. So that's the new regime. All applications under the old regime still going on. But if anybody is making divorce application, the application will go under the new law. And it's so simple that within a short time, if nothing is contested and the person responds, the other party responds, within 3-4 months, the process is over.
Okay. Kevin says that he still doesn't understand something. We'll come back to that. Let's go to Fred on the line. Hello, Fred.
Hi, Uruk and lawyer.
Yeah, Joseph. That's a say.
Actually, I'm not doing some more.
Yeah. Okay. Well, Fred, what do you
Thank you. From the kitchen.
What was it?
I got me. Listen, person, this question can a different from the mood treating.
No, that's fine. Go ahead.
Okay, all right. Person, bisa say, Madam, be mfans o EU family member na. Mfans say ordinary back the crew man say or no EU family member. No, the back the crew man. So maybe for example, if you apply biometric number documents now
So I apply biometric now.
Application and one of us are the biometric now.
Of course, no, we 2 points with that dropping. Also, so I apply biometric now, and then with me assign the other ones.
Me, person, the same documents now, the entering career visa application, and one of us are the biometric.
Okay.
All right. So, Obedua, is he on the line?
Yeah.
Okay. Right. Hello. Good afternoon.
Hello, lawyer.
Good. So once the person goes through the first stage, granted 6 months to enter the UK, when they come, they have to apply for the pre-settled. So they will have to show that they are now in the country. So they have to show residence. You also have to show dependency, depending on your age. If you are over 21, or so to speak, you have to show dependency just as you had to before you entered. So prior dependency and continuing dependency or current dependency. So if they were being remitted funds and all that, and they are now here, how are you going to keep them or maintain them? So you have to show that this is how you are maintaining them. So you need evidence to show that, yes, now they are here, but you are still taking care of them.
You know, Obisa said, the same set of documents now, a year entry clearance, would they be the same set of documents that we use for the residence bit?
But now that the person is here, the entry clearance process is over.
Okay.
So we finished the entry clearance. The person has entered. So you can see that some of the documents the person used before this point cannot be used, so to speak. Because that would prove prior dependency, maybe. What about current dependency or continuing dependency if the person is over 21 years? But other documents will still be necessary. If it is relationship, the same document will be used, either DNA or birth certificate or marriage certificate to show the parent connection. But in terms of dependency, you need current dependency evidence.
Okay. Boss, does it answer your question?
Okay, yeah. Yes, come under 18 anyway. And then
If it's under age, then you do not really bother about dependency. So normally with the underage, they will ask, do you need the mother or father's status? You say yes, and you put in the father or mother status, and that's what they give them.
Oh, okay, all right. So,
But so suffice to say that if the person is here, you are taking care of them. So it might be that you give them money, you buy food for them and all that. But you just have to explain. Sometimes they will come back to you to explain how you are being supported. Then you put your case forward. With children under 21, oftentimes it's straightforward.
Oh, okay, all right.
Okay. All right.
Thank you so much.
Uncle Fred, thank you very much for your contribution and questioning. Well, another person just come through. Hello. Hello.
Hello. In fact, the program number maybe a question also.
Remember how you're quiet down. You're saying.
In fact, I'm beginning Nanaya.
Okay, now. All right. Now you do it.
The fact already. The question is, say US, no. We fancy agents German number they are through the Krumua we are. I'm a good through Krumua. Now, I see agents is Omunia Mamma. Now the woman of Kamen Kobe, the many of the small baby, Menko people baby. Nothing mean Yabia.
So when you are you've got a COS. What they are the organization is not having jobs or shifts for you, as we may put it. But you're allowed to look elsewhere and find shifts to complement whatever you're doing. Is it allowed?
Is that a question?
Question, no. One part, no. Mama, no time. Sometimes we don't have to go far. Me young could be on the bedroom, no. Person, woman, acquire a dual baby, because no one says, and call no, almost any support on driving, call. The bedroom is on him driving. Into no more say on him driving, there. Almost man, a human shifting yet. On those who are almost a man of person could do baby. But I remember the other year.
Mama, quite so waiting me call employer full for
her.
Okay. Pacha, okay, open brofo and I say tree. Right, that's good for the benefit of other people. So what it is that when you arrive, the employer may go through certain processes. I see that it's more procedural than that they don't have it. But if it's the case that job is not ready, you are allowed to work 20 hours with other employers within the care sector or the occupational code sector. Even now, the government is saying that because of the shortage, they can even do unlimited hours with another employer up to 27th of August 2023.
Okay.
So for now, you can just go on and work unlimited hours with another care employer. You don't need COS for that. However,
you have a COS you've come into the country with already.
Exactly.
Okay.
So when you come in, you can work for your main employer and you can also do a top-up of 20 hours with another employer within the care sector.
Okay.
In that case, you don't need another COS. But if you are going beyond 20 hours, then you need COS from that new person or new employer. Now, we are saying that up until 27th of August 2023, the government says that you can work unlimited extra hours. After 27th of August 2023, if the law doesn't change or provisions don't change, they may stop that. That means you have to go back to the 20 hours. In this case, if the existing employer that gave you the COS is still not ready for you, and you cannot work only 20 hours, and you need to do more, then you need to find a new employer. That new employer will need to give you a COS. In that case, you have to go through the process again to get COS. Unfortunately, it is another task, but it would have been what it is.
Okay. 073-99208-468. Nana,
Hello.
good
Sorry.
afternoon.
Good afternoon.
What is it?
Me pastor Nyankopon adom na onse.
Nyame adom yeso ho ye pa. Pache you.
Me pacho we can say bisa lawyer question kakra.
E kwai da.
Me ne partner nete. And yeah, officially, you marry officially, but yeah, oba. Na yeah, we kind of 8 months. Na ne kate kuta na sisi no kuta graduate route no. I do August month September month. Nanko pese uchina akra no so. Na odi eje 2.5 no extending you know.
Na wo ankasa kuta dai.
Me kuta settled, but
okay.
me worrying. I'm still in the process. I'm a divorce. That we didn't want to take the risk of say divorce and
Yeah. And you person be so bet me na graduate akwalai so a sa
akwani say okuta British yinti come pet me bisa say
okuta British
passport
no akwalai no British passport
I will be my yama say me was settled no into original so the eje.
Oh, so it's not say graduate scheme, no, also.
Just say the partner no graduate scheme no so.
Right.
The partner no graduate.
August.
Oh, so it's what shift swift to okay.
Parent route no.
Switch to where you know. Okay, apalan we dia.
Saying when you're 7 months, I'll go 8.
Oh, okay, akwala, right. Anna, ono Anna. Ne biological abano no.
The biological, you know.
The birth certificate, you share, you who say papa is this papa way.
I didn't want to be.
So ne ba a British there. So papa ne ba a British there. Obetumi aye application ejina ne ba British akwala so. Na waye. So ne ba ne ti a ne akwala ne maame ne ti a. Ombe no under the normal family route. But it's still, but sanka papa no kwa no ti baby na akwalai so ni maame ti baby dia. Obetumi ayi bibia from direct access because o hwe ne ba no even though you omo na ti. Nti either way no obetumi agina ne bayi so aye ne de. Why? Nti o pese o switch here, obetumi a switch and FLRFP program no so. Na say we just so na wa move from graduate scheme to sa way.
Okay. And see, if I family life in the general plan of it to me, and I say, anything. Because not, per se, a parent route, no. And only the same as family
so,
life.
Parents, and say, Papa, no, yes, sir. Into your application as a parent or family member of Sakwalai. So what you say? I know your friend parent way. No.
Okay. All right.
So beginning na
one last question. Now address no the same as me. Is that not going to prove any problem?
I'm so lawyer can say so on the one that here among be application no.
And he said on akwalai papa on the banner oti ena one the bay ma me so net yes anet here
Aye.
but one so one on the wo akwalai
Me patch time, then no.
yeah nti mo worry but mo we are no who say you are cohabitees and I'm matching for 2 years me boy.
Me patch wine.
Yeah, so it doesn't even matter. And so obetumi your application, so obejina also and also obejina akwala no so because also what there but it's even better so obejina akwala no so because akwala no woman no you share akwala no interest more. Says papa yi eni ho a be akwala no hwe mu ba ya din. Wo there we penny obetumi ahwe wo ho. So what you say? Aha, so by your application obejina akwala no so. But because maame no ewo mu ni yeah, they no emma no sometimes some of the mawa na ya mao instead say ebe man as a parent na ya no ma kwada no akwai no partner but it doesn't really matter the partner is open 2.5 but known to me any say obakasa or yef as under the 5-year route so jina kwala no so dia onjina onto aya omo ma no 5-year route no omo de never 10-year dia no so but so ojina wo so dia and the obeye no say owarefo a ojina na yere so agi asetena nti eno no so meet 5-year route requirement ne dia obetumi akwa 5-year we no ase why
Me patch you.
nti na tibia no kwanda ho ma no
Me patch you. Me that's it. Young people sure.
I mean, sure.
Alright.
So thank you very much. Kevin Asamoah had an issue here. I'll say I still don't understand. Could you explain further no or can whether the course is still available any other? Kevin Asamoah, your previous question was this one. Let me see if I can pick that one up and bring it again. Was say, does it mean the Home Office has stopped issuing cost to agencies from the countries, which include Ghana?
we explained that okay
It says he still doesn't understand.
all right so what we are saying is such agencies apply as employers because they present that they have jobs. And therefore they need people to work. Now, the key thing is this. Whilst the agency or the employer cannot go directly to recruit as before, the employer will just relax, but they have the power to accept when people come on board. So the employer or the agency will just relax. And when people apply through or the application come through, they check to see if they would consider such people. And because they have the license to recruit, they can recruit those people. So they can accept the application. Okay, those are the terms you have to get right. They can accept the application from those individuals.
Okay. All right.
So Home Office hasn't stopped. Because the license is also required for internal job vacancies. So if the person is within, they will still need COS. If the person is outside, they still need COS. So Kevin, Home Office hasn't stopped. What the government has restricted is that rather than going and campaigning to get people, this time you wait. And people will come to you instead.
You assess them, and if they are employable,
exactly.
You pick that. Okay.
And that's actually what is happening. Because even those recruiting parents, before, by now, they don't. By word of mouth and others, people know that there's a job somewhere, and they apply. And they go through the process, and they get offered.
Okay. Now, let's pick up this other one. We've got just a few minutes to handle the questions, and we'll do our quiz and look at it now. Recently, most of the job adverts for care workers require applicants who are already in the UK. Does this relate to the recent updates by the UK government?
No, it's because those people accepting jobs have their licenses restricted to internal use.
Okay. All right. Kevin comes in again. If the red list countries are not allowing to come to the UK to work as a carer, why is Home Office still issuing costs to the agencies?
We are not saying the people inside the red list countries are not allowed to come and work. That's the whole, what is the essence of this topic? They are allowed
to come in, but
they have to do it on their own. They should not
direct.
be. Exactly. So, yes, so the agent, so the employer cannot come for you.
But you can go to
go to the employer.
Okay.
Yeah. So it's a case of the Muhammad going to the mountain instead of mountain moving. So mountain will stay, but you can move.
All right. Another one here says, just a quick question. I was wondering if I could get a visa on arrival in Ghana with a British passport currently. I think I will hazard the answer here. Currently, it's done in some circumstances. So you'd have to find out from the Ghana High Commission if they can facilitate that for you. I think it's done in some circumstances. That's the hazard answer I'll give you. Greetings to all, Dr. Tina Rice-Sachs. Doctor, thank you very much. Good evening to you as well. 0739920848, 0795042278. Those are text messages and for WhatsApp messages as well. Okay, I think we've done what's the name? The divorce question. Somebody says, I'm a safety officer. I want to know details about the sponsorship. The link to UK job sponsorship. Safety officer. Is it under the categorization?
Right. Well, for today's conversation, safety officer does not. But I suppose the person who, I'm not sure whether is an employer that wants to apply for license or a safety officer who wants a job. It's not clear.
Mr. Nati, if you could come back to us, that would be very useful so lawyer can get you an answer for that. Kevin comes again, great lawyer, got the explanation. Yeah, I think the terms
can be confusing.
Yeah. But your explanation has really brought it down to earth. There's a big misunderstanding of the guidelines, the Home Office document. I think they are clear. They are quite clear, except that sometimes it is interpretation of the whole thing. They say the organizations can come for you, but you can go to them.
Exactly.
That's the whole essence.
Yes.
Of it. Because if a country on the red list, then it means that WHO standards mean that they can't directly, without a government-to-government agreement, recruit people from one country to the other. In this case, from, say, Ghana to the UK. But if somebody is in Ghana, qualifies for a post that has been advertised, and he has chanced on it, and has advertised, and the people think that, well, this person qualifies, he has the skill set to work for me, nothing stops an organization from doing that. And that's the essence of the whole thing, isn't it?
Yes, it is. So, but let me put it in simple terms this way, that individuals generally, it doesn't matter which country in which they live, cannot be restricted from applying for a job abroad. That's the first point. That's the default position.
That's right.
So no restriction for individuals. Not even WHO can restrict individuals. So no restriction for individuals. There are restrictions for organizations and groups that want such individuals.
That's right.
And therefore, you need permission. Now, if you are on a red list, if the country is on the red list, or if the individual lives in the red list country, then you need permission to go for that individual. And they are saying, no permission now. Because there's no restriction for the individual. If you're able to signal the individual, whichever signal, and the individual picks your signal and comes to you, then it's the individual who has followed the signal to come for a job. And if you think the individual qualifies for the position or the role, then of course you select the person and offer the person the role. So it's the other way around. So let's focus on the fact that individuals can go for the job abroad.
Okay.
But those employers abroad cannot go to the individuals to say that I have a job for you. Can you consider it?
Okay. So what I'm going to do is to put the link that has the index there on the chat, so all of us can pick that up and read for ourselves as well. But in any case, uh, I know wonderful lawyers, senior partners, friends in the legal industry, especially from BWF solicitors. We say, this is the link, read for yourself. But if you need any help, please come over and we'll talk to you. 0208 493 7340. Yes, you're asking for the list to be shared, and this is it. When you go to the Home Office, gov.uk, government/publications, Code of Practice for International Recruitment, that will be your key phrase. Code of Practice for the International Recruitment of Health and Social Care Personnel. Read that. It's about 12 or so pages. There are scenarios, there are conditions, there are links there that explain everything. Don't get it twisted. But in any case, if you are confused, I've given you the number again: 0208 493 7340. 0208 493 7340 or 077 127 61884. That's for BWF solicitors. Foreign nurses and other health professionals can, and underline can, legally enter the UK to work. And after this break, we'll come with a quiz, and then we'll draw the curtain down. BWF solicitors, thank you.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Anyway, we are back, and we're going to go to our quiz, and then we go down to the end of the question. Oh boy, oh boy, oh boy. Okay. Whoever looked, they look very well. Anyway,
And they didn't see anything.
they did- Okay, so let's come here. Mr. and Mrs. Brown executed their Mirror wills in 2020. They had instructed their solicitor to draft mirror wills to leave all the assets to each other, and then on the second death to Mr. Lucky. Mr. Lucky was not related to the Browns, but was treated by them as a son. Mr. Browns did not have their own two sons, but they were not intended to inherit. Unfortunately, due to an error on the part of their solicitor, which he fully admitted, they each signed the will intended for the other. The two sons of Mr. and Mrs. Brown disputed the will, saying the wills were invalid because of the error. If they succeeded, then it follows that their parents died intestate and they will inherit them and not Mr. Lucky. Mr. Lucky challenged them in court. What is likely to be the outcome of the court's decision into the error? The court will rectify the error and make the will valid. The court cannot impose conditions on the will because the Browns signed the wrong will. The Browns' sons will inherit their parents as they died intestate. So it's a bit of a tricky one. Mr. and Mrs. Brown executed their mirror wills. I want to believe, lawyer, that if we say mirror will, then it means that I do one for you, you do one for me. Same thing, isn't it?
Yes.
Okay. All right. So then they instructed their solicitor to drive the mirror wills, leave all their assets to each other, and then on the second death to Mr. Lucky. Mr. Lucky was not related to the Browns, but was treated by them as a son. The Browns did not have their own two sons, but they were not intended to inherit. Unfortunately, due to an error on the part of their solicitor, which he fully admitted, they each signed the will the will intended for the other. The two sons of Mr. and Mrs. Brown disputed the will, saying the wills were invalid because of the error. If they succeeded, then it follows that their parents died intestate and they will inherit them and not Mr. Lucky. Mr. Lucky challenged them in court. What's likely to be the outcome of the court's decision in relation to the error? One, the court will rectify the error and make the will valid. Two, the court cannot impose conditions on the will because the Browns signed the will. Then three, the Browns' sons will inherit their parents as they died intestate. So what are the answers that are coming? As I said, we'll just pick up the answers quickly, get the lawyer to explain the answer, and we move on. One from Kweju 4 says, number 2, the court cannot impose conditions on the will because the Browns signed that particular will. That's Kweju 4's answer. What's yours? Let's do that quickly, and then we can draw the curtains down. Okay, now let me go to Laura. Per your initial explanation, we realized that lawyers can make mistakes. To guys human, as we said. The lawyers have admitted that they made a mistake. Rebecca Mwako also says number 2. Okay. Becky, let me put that one on there for you. Number 2. Okay. Now the lawyers made a mistake. The application has been made to court. Would the court accept the lawyer's admission and correct that?
Right. Okay. Are we proceeding to the answer?
Yes, please.
Oh, okay, right. So we have established that wills are made, and sometimes we have to check whether it's a clerical error. Okay. In this particular instance, the mirror wills were signed by the wrong people.
Okay.
So instead of the woman signing her own will, for whatever reason, the lawyer gave that of the woman to the man, and the other, and vice versa. Mm-hmm. So the question is this my will or not? Then we can say, no, that is invalid. But if that is not accepted and allowed by a court, such wills cannot go be used. So the law says that under Section 20 of Administrative Justice Act, the court has the power to look to have the will corrected. Okay. Having the will corrected means that they will accept that this is for that and this is for, in this case, the signatures can be looked at. Mm-hmm. So the first part is what the error is, the clerical error. And the second part is whether the intention is not clear. Okay. So if the intention is not clear, the court has to interpret under Section 9. Mm-hmm. And if it's a clerical error, the court will look to have it also corrected and extend to section 20. So in this case, if it's a case like that, the court, if the person who is the beneficiary, he's the one going to court, because it's always the beneficiary who will go to court. Otherwise, they lose out. So he goes to court. Mr. Lucky goes to court to say that, hang on, this will is obviously signed by mistake. So court should allow it to be corrected. Court will allow that will to be corrected so that it stands
Okay.
under the provisions of the law.
So in this case, the answer to that is 1.
Is that, yes, court will allow the will to be corrected.
Okay. All right. So there's no dispute about that, because if you go to Nugget, for instance, that was made succinctly clear that an application can be made to court to have an invalid will rectified due to 1, a clerical error, failure to understand the instructions of the person who was making the will. A clerical error can be made by a solicitor, a clerk, a typist, or the testator when she or he adds something by mistake or omits something, or she intended to insert. In this case, I think in our quiz, it says, the scenario says that it was signed the other way. So then they needed to just swap it. It wasn't done under duress. It was a mistake, and the lawyer admitted it. If you look at the question, it says that unfortunately, due to an error on the part, you look at the second paragraph of the solicitor, which he fully admitted, and the honorable judge obviously granted that. So the answer is number 1. The court will rectify the error and make the will valid. Well, lawyer, then let me come back to you quickly, and you just give us a brief summary before we draw the curtains down.
Thank you very much, viewers and listeners, for making time with us up to this point. Today, we asked ourselves a simple question. Can nurses and other health professionals enter the UK legally to work, even if they live in a red list country? Our answer is yes, they can. And the reasons are, the country in which they live is on a red list. It means that that country is losing its professionals. So employers cannot go directly to that country to recruit people from there. However, because individuals in that country cannot be prevented from finding jobs abroad, they can find their own job and apply, and if successful, enter the country to work, especially the UK. So the restriction that a country is on a red list is only valid or necessary if in the past employers were going there to recruit directly. But if the individuals now make their own application, then the restriction will not affect such individuals. That is the distinction. And therefore, if you live in a country that is on the red list, you should not be so worried. If you meet the criteria of the employer, the job advert, the job spec, and all that, and you are successful, you'll be able to enter that country to work for that employer. The difference is no employer recruitment. However, individuals' own search and find is allowed. Thank you.
Well, thank you very much, Lawyer Charles Asmah, for your great insight into this whole thing, and the question has been very clearly answered. On behalf of everybody that's been part of this production, I want to say thank you very much. Thank you to BWF Solicitors for giving us the opportunity to come your way again to bring you a very insightful topic and discussion. And to my producer, Dr. and Professor Ade, and to Sheila, and definitely my artist, Padmo Dude. To Lawyer Charles Asmah, thank you. To Uncle Ben, thank you. To Cynthia, to Eunice, and to Sandra, and all the wonderful lawyers from BWF Solicitors, we say thank you so very much. And to you, my wonderful I want to say thanks for your time, and I believe that we will come back together again same time next week on the same platform with another very interesting topic. Until then, please be good. God bless you and stay safe. My name is Owusu Frimpong once again, and it has been the community and the law.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, yeah, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done?